Welcome to another legal update, but this update is the big one. At least it's the one we've all been waiting for, at least I've all been waiting for. It's us announcing that we've finally won our Baphomet Monument battle in Arkansas. But I need to take a step back and kind of explain the background. Most people probably already know it, but in case people are just coming in and are only vaguely aware of what's going on here, here's the story. About 2014, the Satanic Temple was just getting started, was rather more of a concept with a very small group of people working on these projects. And we really wanted to kind of announce ourselves not by issuing a bunch of religious fiats and saying, follow me, or something like that. But we really wanted to be active out in the world to show people what our values are. And primarily, we were focusing on fighting back against the rising tide of theocracy in the United States. And in Oklahoma, they were pushing, they already had a Ten Commandments monument on their Capitol grounds. And these battle for Ten Commandments representation on public grounds are being fought in multiple locations. And it was part of a Christian nationalist national effort to create bill mill legislation and give to their lackeys in different governments in different states across the nation, try to get them to pass them, and then try to survive the legal challenges to further erode the separation of church and state. And putting up Ten Commandments monuments was one of those arguments. There were certain precedent cases that they were using to establish this idea that Ten Commandments monuments were actually legal on the Capitol grounds or on public grounds, on government property. Despite many Ten Commandments monuments being taken down that were standalone, there's a few cases in which they were allowed to stay. And Van Orden versus Perry in Texas is one in particular that they would always point to and say that Ten Commandments monument was allowed to stay because it was thought or said to serve a secular purpose, and there wasn't evidence of religious discrimination, and it had been there 40 years or more. So after a while, they declare it historical and allow it to stay. In Oklahoma, we put forward that we wanted to put a Baphomet monument up. And in fact, we conceived of the Baphomet monument during this battle. We first sent a letter to Oklahoma saying we wanted to do this, and then we came up with the design for what monument we would use. And then we had somebody put that together, a sculptor put it together, and that took a full year and a half, and we had to raise all the funds to create this monument. And at the point where we were finally unveiling the monument and we were going to announce that we were going to press litigation against Oklahoma, the Oklahoma Supreme Court declared the Ten Commandments monument illegal, a breach of the separation of church and state, and the Ten Commandments had to come down. In that case, we had no need to put the Baphomet there, and we moved our case immediately over to Arkansas, and that was 2015 or 2016. We started fighting that battle. And in Arkansas, we got really quite far in the process. We went to the Capitol Commission meetings and presented our diagrams, design, the philosophical background to the Baphomet monument, what it meant to us, and it fit all their criteria. The argument they were making for putting up the Ten Commandments monument was that it was privately donated and therefore it didn't constitute government speech, but that was opening the door to other private donations, especially if they were going to accept religious donations. The government had no place engaging in viewpoint discrimination, so they couldn't just say on the grounds that we were Satanists alone that they wouldn't accept our monument. Except that's pretty much what they did. They claimed that because they had passed a bill that allowed for the Ten Commandments monument to be on the Capitol grounds, we would likewise need to pass a bill specifically for the Baphomet monument. Well, we sought sponsorship amongst the legislators in Arkansas, asking them to sponsor our monument, and many of them got back and were very open about the fact that they wouldn't support it or us because we were Satanists, which only helps kind of strengthen our case. And in particular, there was a senator who was the sponsor of the Ten Commandments bill who seemed to not be able to get enough of going around and talking about the religious function of the monument, despite the legal argument they were trying to make that it had a secular purpose. And we would make fun of him online, especially on Twitter at the time. And he would always rise to the bait, and he would always say the stupidest things that would make it clear that his arguments in court were absolutely disingenuous. And what really makes this gratifying is that a lot of his idiotic comments made it into the final ruling. So we can laugh at him now and say it's exactly as we told him it was going to be. Little shithead that he is. But a lot of this is cataloged in the movie Hail Satan, the documentary about us that came out in 2019. This has been a long, arduous, hard legal battle. And I have with us today the other two plaintiffs in the case. I was a personal plaintiff in this Arkansas case. I presented the plans to the commission and all of that. And as Arkansas residents, Mason and Erica were also plaintiffs in the case. Mason, you may recognize as the bow tie guy from the Hail Satan documentary. And our lawyers in this case, Matt Kazai and Stu DeHaan, are also here. And it was this past Tuesday night at like a quarter after 11 p.m., I got a call from Stu. And the last thing I expected from him was him to say that we had won the Arkansas case, but that's not exactly what he said. He called me and he said, "Dude, I think we won Arkansas." And I said, "What?" And then he said, "No, hang on." And then I was like, "Fuck, Stu, what is it?" And he's like, "Yeah, no, I think we won." And I said, "Really?" And he said, "Hang on." And then and then sweat's breaking out on my brow. And this has been years in coming. Like this has been in the background of my life for some time. Just this kind of thing weighing on me, the Arkansas case. So that was a really long couple of minutes before Stu was like, "Yeah, we looks like we won." And it's a 148-page ruling, and I feel like it's worth reading every bit of it because not only does it validate us on every point we made, and not only does it drag former Senator Rapert in ways that are hilarious, but it also goes into things like our legitimacy as a religion, finding again in favor of it, which has already previously happened in federal court, and we've already been recognized by the IRS. But all of these cases, this has kind of a compounding effect, adds a real shielding buffer, I think, for the future when we're challenged again. And I think this strengthens our cases going forward. And to be honest, it's emboldened us, I think, quite a bit more. And I don't see that this has gotten a ton of attention so far. I think the order is stayed for the Ten Commandments to come down pending appeal from the state of Arkansas. The governor has said, I believe, I haven't seen it personally, but I was told that she posted somewhere that they are going to appeal. I don't think it doesn't look like their current Secretary of State is any smarter than the one that was previously there or Attorney General. So I don't know how good of a case they'll make or how amenable the circuit court will be to hearing it out over there. But we'll see. They have 30 days to appeal, but it's a very solid ruling. I would think it would be difficult to overturn on appeal, but that I think is, of course, is a question for Matt or Stu. What do you expect to see, either of you fellas, from the appeal within the next 30 days?
Within the next 30 days, we'll just see a notice of appeal. They theoretically could file a post-judgment motion, which is, Judge, I raised this argument, you didn't rule on it, or something like that. But those are frowned upon in the courts. So more likely than not, 28 days out from the 31st, which I think is April 28th, we should see a notice of appeal. They could do it sooner, but that's the deadline.
So that's all they have to do is say we're going to appeal. They don't have to put in a brief that gives their arguments that they're going to present for appeal.
Correct.
So how long do they have before they have to present those arguments?
Ordinarily, I think it's 30. I think it's
I
40 days from the date you filed the notice of appeal. But what will happen is sorry, someone's in the background. What will happen is they're going to issue the notice of appeal. They'll create an Eighth Circuit case number. Within a couple or few days, the Eighth Circuit will issue a form briefing schedule, and that'll let us know the threshold dates. So theirs should be due, if I remember right, 40 days out. Ours will be due, if I remember right, 30 days out, and then their reply will be due, I think, 15 days out. Unlike, or maybe actually quite like it was at the trial level, the time on appeal is a lot more attenuated than a usual district court case. Ironically, with how slow things went at the district court, it'll actually be relatively quite fast from our perspective. You can get extensions on your deadlines, probably like 90 days worth. So it could be like 6 months out, 120 or so days out from the notice of appeal deadline. So we might not see a brief until fall, theoretically.
I look at the ruling and it tells me that we did everything right on every action we took. That was also taken as validating towards our claims in general, from going to the grounds commission to present our plan, to going to the different people in the legislature in Arkansas to try to get their support. Every move we made 100% of the way was also used in the ruling to establish that we went through the process and we were clearly not treated equally by the state. We're not allowed to compete on an equal level with another religious bit of expression on the public grounds. But is there anything you think we might have done different or would do different if we were doing this again?
I don't think so. I mean, there were a lot of discovery battles that you don't see in this opinion, but everything that we fought about in terms of discovery, we really needed. Nothing, I don't see anything that raises any eyebrows from an appellate standpoint. When you are appealing, you can appeal from the very beginning of the case. So my prediction is they're probably going to strongly contest intervention in the first place as to us if they're wanting to particularly attack our judgment. But as a matter of efficiency, they're probably going to need to really specifically hone in on the Establishment Clause issue because that's the common ground of all three plaintiffs.
Yeah, but I gotta say, they used the depositions to, I felt strongly they were trying to harass me through the depositions. I thought I was pissed off when I was going to the deposition of Rapert that he posted publicly that I was coming to town and where I'd be at a certain time. And I think he was very pointedly trying to make things dangerous for me in Arkansas when I was there for the Ten Commandments being installed. He was going to state troopers that were there, appealing to them to arrest me because I had a warrant open in Mississippi for putting my balls on the grave of Fred Phelps's mother. And I feel like this was some real bitter litigation, but I was a little pissed about having to be deposed 7 hours straight, 2 days in a row, and sometimes under the most arbitrary and insulting questions. And there were a couple times where we just said, you're going to have to talk to the judge if you really want to get into this territory, because I feel like they were going low. They started asking me questions about family, friends, acquaintances, and things like that. And I felt like in certain ways that's a threatening gesture in which they're telling you they're going to put these things on public record and they're going to make things dangerous for you, is how I felt. I know Mason and Erica also went through depositions, but I think they were a little less brutal than mine. I think they focused in on me, but I don't think you guys dealt with 2 7-hour days each, did you?
No, ours was one day, about 3 hours apiece, probably, and ours was
way less serious, assumedly, than yours. Um,
Yours was quite entertaining.
yeah, I mean, the highlight was just them bringing the folder of all my old tweets and Facebook posts printed out like they had a smoking gun, but instead they found out that Raypert butt chugs Kool-Aid. So yeah.
What was the butt chugging Kool-Aid comment in reference to?
So Michael
That came up quite a bit
Cantrell,
afterwards. It was like the thing with your deposition.
yeah, he started reading my tweets out at the end of it, and he had one. He slid it over, and he's like, and he read it, in that voice of his that there's drinking your chosen religion's Kool-Aid, then there's the Raypert style butt chugging the Kool-Aid, and like he was like, did I read this correct? And I was like, yeah, I think so. But yeah, that was about it. That was the extent of our depositions.
Well, I mean, Raypert's deposition was a whole different story. I don't think you were there, Mason. I know Erica was there, but that man wasn't well in the head. I was reminiscing yesterday about how at one point he pointed to me and said he admits that there's a large population of homosexuals within the Satanic Temple. And I thought, who is he trying to convey this to, that he thinks it's going to that it's going to damage our reputation in some way? And he also stopped the deposition to put on record that that a woman in the room was intimidating him by the way she was looking at him.
What did you say to the Liberty Counsel lawyer? Was there something about BDSM or something?
No, the Attorney General's office, their lawyer was asking me about BDSM, and I don't even remember why. I think they thought they found something that associated Baphomet with BDSM or something. They wanted to make the case that if the Baphomet monument were to be brought onto the Capitol grounds, you could expect to see the same things on their Capitol grounds that we saw at our private unveiling event. So, of course, there were all kinds of things going on at the unveiling event, and they found everything they could see written about it. And then for some reason, this made him ask about BDSM. And then he was asking me, what does BDSM stand for? And I was sitting there and I was thinking, like, I have no fucking clue, honestly. Like, BDSM is just like an acronym for me. I know what, generally the idea, but I really don't know what the words it stands for are. And he wasn't buying this. He thought I must know. And then he said, well, could it possibly stand for, and I still don't know what it stands for, but then he said, like he rattled it off. And then I looked him in the eye and I said, I don't think you're guessing. And then I gave my eyebrow wiggle. Another one that was funny is when they were trying to establish that Gray faction undermines our claim to uphold science as an arbiter of truth claims, because the position of Gray faction in dissociative identity disorder, which is a whole other topic, it contradicts what is present in the DSM. But it was taking forever to get there, to the point where the other lawyers, we were interveners in this case, which means, our case was kind of tacked on to a case that was brought by the Freedom from Religion Foundation and the ACLU. It was different in content in that we weren't just suing to have the Ten Commandments monument taken down. We were suing that we were discriminated against for not allowing our monument to go up, and therefore the Ten Commandments needed to either come down or our monument go up. So it was different in that way, but the facts were similar enough that they put the cases together, so the other lawyers were there. And the other lawyers started getting very upset at this line of questioning that was going on ad nauseum about Gray faction, only for that punchline, that idea that we didn't believe in our own religion, because if we had a view that contradicted the DSM, then we must not believe in science. It was really convoluted. And what happened in this ruling is it was ruled on summary judgment, which is to say it could have gone to trial. But we motioned for summary judgment, meaning that there were no dispute of facts. It was just a dispute of where the law falls when evaluating these facts, and therefore it didn't need to go to trial. But I think it would have really been a circus if it had gone to trial, because Arkansas didn't seem to know exactly what to do with the case at all.
And something that I'll point out too that I think was really pertinent is the first defense that they always make is that Satanism or the Satanic Temple, and specifically, is not a real religion. That's always the first thing that they argue past the procedural issues. So the intervention, for example, was that our argument was if the ACLU wins, we lose because then the Ten Commandments monument comes down. Ours doesn't get a chance. Of course, if the state wins, we lose because then it stands in isolation. That's why we got the intervention status. So once we get past all the procedural stuff, they say the Satanic Temple is not a real religion. They attack it on multiple grounds, like the Gray Faction thing. But what's very interesting to me is they cited the Scottsdale case, which was in the federal court in Arizona. And that was a case we ultimately lost. But in analyzing whether or not Satanism and the Satanic Temple is a real religion, so to speak, they used some of the framework from that ruling because we didn't lose on those grounds in Scottsdale. We lost on whether it was administrative or a legislative decision to keep us from giving our invocation in the city council. So now we have two rulings from federal court. We have Scottsdale, and now we have Arkansas that says, no, that's not a defense. Satanism is the real religion. I feel like that, going forward in any other lawsuits that we do, that's going to be huge because we're building this body of law that says Satanism is legit. And that's going to continue to erode. That's going to become a farce of a defense eventually when this has already been ruled on. So I think this goes to say, like, even when we lose specific cases on certain grounds, it doesn't mean we're not building towards something. And I think that makes this Arkansas case even more powerful in that this bolsters a ruling we already had. That's the main defense on a lot of these states, is that there's only one real religion, it's Christianity. The rest aren't really legitimate, which is such a bullshit thing to claim. But now we've got rulings to say, that's just not true. So that's another thing I think is one of the most important parts of this ruling.
How impactful do you think this ruling is nationwide? What do you think those who create this kind of bill mill legislation to try to push for Ten Commandments monuments, what do you think they're thinking? Like, how big of a setback do you think they feel this is, and how much should this embolden us moving on to other territories?
Well, surely this is going to get appealed. I mean, I think they feel the cosmic duty, as you will, to appeal this, even if they don't have that great of an argument. But I think if the Eighth Circuit, the Circuit Court and the Appellate Court rules in their favor, now it's precedent. So now they'd have to overturn the law. And of course, the whole thing with what we're doing here is we're not trying to change the law. We're trying to have the law enforced as it's written. And I think if we've got precedent on this in the Court of Appeals, now they're going to have to ask for a change of the law. They're going to have to overturn the entire schema of religious liberties in order to defeat it. So if we get a win in the appellate court and we have precedent, now the law is automatically in our favor. And I think that's been the goal since day one, is to set precedent that we're legitimate, that we have a place at the table, and that these bills are per se unconstitutional. Not that we have to fight that they're unconstitutional. It's now going to be per se constitutional. That's what I think now. So they still have got another bite at the apple. They got the appellate rights. If it gets overturned, we're back to square one. But that was such a solid ruling, and it was so lengthy, and it had so many points, and it was so clear that this was unconstitutional, that I have high hopes that we're going to prevail in the Eighth Circuit, and that we're going to have precedent then, and it's going to be much, much harder for them to make an argument with a straight face that their Ten Commandments and these essentially religious monopoly bills are constitutional.
Do you think there's a strong chance the appeals court won't even hear the appeal?
I think they get we get appeal by right in the circuit court, but Matthew's more of an appellate attorney than I am, so he could probably answer that better.
You get a direct appeal by right, meaning you have district judge, which is a one judge trial level. You go up 3-judge appellate panel. You're entitled to that. And everything thereafter is discretionary. Theoretically, you could get an en banc, which is, I think, 9 appellate judges. And then you can also petition for certiorari to the United States Supreme Court, but they take like 2% of cases. So I don't think this is a good contender for it.
Yeah, because
No,
here's the thing.
I know they swore, like Rapert swore they'd take this all the way to the Supreme Court, and I think he has the supreme confidence that the Supreme Court would rule in his favor. But I feel like if the Supreme Court wanted a case in which they could further erode the separation of church and state in favor of putting up religious monuments like the Ten Commandments, this is not the one. And particularly, Rapert did so much to make this a really poor case for that cause if they wanted to push it forward. He's an absolute fucking failure, and he should be mocked and laughed at everywhere he goes.
I agree, and it's like Matthew said. They automatically, everyone gets a right at the circuit court, and there's a three-court panel, a three-judge panel, and then it can go to the nine-judge. But exactly, if they're going to try to upend religious liberty and turn the whole concept into Christian supremacy or religious monopoly, religious liberty monopoly, they have to have the right case, right? It has to be the one that's teed up to be the one to overturn the whole schema, upend religious liberty, essentially. And what they have is a senator who's a fucking buffoon, who made this as hard as possible for them to get certiorari and have this overturned, because everything he said was basically pushing an unconstitutional agenda. I don't know how they get past that, especially in the Supreme Court, even with this composition. But who knows? All bets are off with this regime.
Right. Maybe I didn't clarify that enough earlier on, but what we mean about him undermining the case is that as is typical now, the argument will be made that the Ten Commandments serves a secular function in informing people about our heritage and history, based on this revisionist idea that constitutional law was based upon the Ten Commandments, which makes zero sense whatsoever. The First Amendment contradicts a full four of the Ten Commandments. And so it's hard to believe that played any role in conceiving of democratic pluralistic society based on religious liberty. It just doesn't match up, but that's the argument they make. It's a weak argument to begin with, insensible, but it's also further insulting when they make that argument on paper and they make it in court, in what this guy was doing when he was senator at the time. Rapert was going around on TV, going to churches, and he was openly saying that they were bringing the gospel to the public square, that they were teaching people the word of God and putting the word of God in their faces on the Capitol grounds. So he was completely undermining the legal arguments they were making publicly, but expecting that these kinds of things would be separated, that they could make the legal arguments in the court of law, while in the public they could make a completely different argument, as though the judge wouldn't see those things. And the judge made very clear in the ruling that she saw those things.
I think this is a symptom of them getting away with this shit for far too long, where they can talk out both sides of their mouth. They can be a grifter. They can say, "Oh no, this is about history and heritage, and there's Moses in the Supreme Court." Yeah, but the whole point of that is there's a lot of different images in the Supreme Court, and that's what we're arguing, is that this is about pluralism. You don't get a religious monopoly because there's an image of Moses in the Supreme Court. It's so disingenuous and it's so phony, but they keep getting away with it. And I think this is pure hubris on the part of Rapert, to think he could talk out both sides of his mouth like this.
Well, the argument they made did not account for us. The argument they were making showed that they were fully prepared to fight against the ACLU and the Freedom from Religion Foundation, but they did not know how to handle the argument of pluralism, because they did not expect that another group was going to come along and say, "Sounds good to us, let us in." Because they were arguing, like you said, that there's the Ten Commandments are displayed in the art on the wall of the Supreme Court itself, and while failing to mention that there's a mural that shows lawmakers throughout history, and many of them have religious implications, like Confucius, Hammurabi, and it's not just the Ten Commandments in isolation. So they did nothing to address the question of other viewpoints coming in. And in fact, once we were there, they never bothered to figure that argument out either, because you're dealing with people who were as tender-headed as Jason Raper and his lawyers who weren't much better.
I like the phrase tender-headed. That's a
What
sweet
does
way
this
to
look
put
like
it.
in Arkansas? Was there a lot of local news about it? Mason, Erica, did you two deal with any trouble with the local population or anything from having been plaintiffs and being on the record as you were?
I it was, I don't know, personally, I expected the news to hit harder and faster than it did. The local news picked it up sort of later in the following day. You'd be surprised. In my line of work, I see a lot of people and a lot of Republicans, and a lot of Republicans that I'm friends with don't like Rapert. They've never cared for Rapert, and there's some Republican folks in town who are pretty tight with our governor, everything, who sort of have secretly told me before that they kind of like that we're fucking with Rapert so hard like this because no one can stand him. I guess he's tender-headed, but I think he's got a fiery tongue also. So
Yeah, we've seen lots of prayers happening. As far as when the original suit was filed and our names were in the papers, that was a little bit fun. But on this last round, we haven't seen anything. The fact that the news rolled out on April Fool's Day, I don't know if that helped or hurt the situation, because I think a lot of folks really don't believe it yet.
I think I think it'll really strike when it gets to the point that they actually take the Ten Commandments down. I think that's when we'll see Glenn Beck cry again, and that's when we'll see an outbreak of Christian nationalist tears. But they were not happy about it when we brought the Baphomet monument to the Capitol for a rally we had there, and that ended up being the climactic scene of Hail Satan. But the problem is that the Hail Satan camera crew was really dedicated to keeping their one camera or two right by the stage, so they missed all the action surrounding that. And when I was walking up to go to the podium, one of the people with me asked one of the troopers there, because there were a bunch of them, to escort us, and they essentially said, "Fuck no, you're on your own." And we were walking, and it's an open carry state, and I realized that the podium I was going to be at was, right outside a public building with opening windows, and then there were people out on the grass across from the Capitol just showing us that they had guns in their waistbands and things like that. Vice was there. A Vice cameraman chased off some guys with guns just by putting the camera on them and asking them what they were up to, what they were planning, what was going on. It was a pretty harrowing situation. Something that they also missed was we had the Nazis there protesting us, and we made fun of them. And we had our crew was getting nearly got in a shoving match with people trying to block the truck from moving, park the Baphomet there. But a bigger kind of point with that to me was them acknowledging that we had the right to have that rally and bring the Baphomet there to do it. And it made me wonder how they were distinguishing that from our right to have the Baphomet there if they were going to have the Ten Commandments there at all. Like, how were they limiting that idea of rights and limiting that notion of government viewpoint neutrality only to that day? To the point where, even though I'm surprised and happy we won, because it seems like a lot of times judges search for anything in which they can rule against us on a technicality, I still don't really know of a credible ruling that would have gone another way. I don't know how a ruling against us would have actually looked. And Matt and Stu, you must have considered that. I mean, we've had all these years waiting for this ruling to be handed down. What is it? I mean, it's great to get this victory, right? I don't know if we should be as surprised as we are.
I wasn't surprised. I mean, given the public comments that Rayburn made, it did make it pretty hard for us to lose. Um, maybe in a different set of factual circumstances where they really go hard and they say, hey, this Ten Commandments monument is going to go into our local state capitol grounds museum. It's going to be surrounded by all these other historical artifacts, other things talking about the rule of law, maybe. I could see that surviving. Or if it's part of maybe, especially if it's part of other, as you mentioned, Hammurabi, Confucius, pretty much every courtroom that I've been in, every Supreme Court courtroom or around it will have homages to Hammurabi, Confucius, Romans, and Egyptians. Those are like the regularly seen pillars of our rule of law. So not on these facts though.
Well, I mean, in Scottsdale, I couldn't see a way we would lose. I felt it was obvious that we were discriminated against. And the Scottsdale case was related to us trying to give an invocation before a city council meeting where they would often open with a Christian prayer given by somebody from the public. So somebody within the Satanic Temple applied to give an invocation. They put us on the calendar, and then they took us off, and simply because we were us, and we sued. And we also got the Freedom of Information Act request towards the city council speaking on this issue, and we saw openly discriminatory statements about us. City council members saying that they weren't going to allow us to speak because we were Satanists. And I thought the case for discrimination was crystal clear, and yet, as you said, they ruled unambiguously that we are a religion, but at the same time said it was ambiguous to the judge as to whether or not it was just an administrator who was working from his best knowledge of what kind of the unspoken rules were about this rather than actual discrimination. And it was to the point where I was thinking that in our Boston case, making me think that if a judge doesn't want to see discrimination, they're just not going to accept anything as evidence of it unless the accused is found to have openly said that they're discriminating for that reason. Even in Scottsdale, that seemed to be the case and didn't come around. So I wasn't, even though I felt like we had such a strong footing on this case, after all we've been through, I didn't feel necessarily entirely confident that it would come out our way.
Yeah, and I agree. I think after the Scottsdale case, that was pretty demoralizing because the public commentary or the public commentary that the legislatures at the city level were making were unambiguously that they were discriminating against us due to our religion. So yeah, that came down on, I guess, what people would call a technicality. And that was definitely demoralizing. But I even after that loss, I mean, we've talked about this and we're going, this is different. There is the fact and dispute. The reason that went to trial in Scottsdale, meaning there was a fact and dispute, was whether it was an administrative or a legislative decision. Here, there was nothing. Nobody disagreed on a single fact in this case. And everyone agreed on that, including the parties. So this had to go down on summary judgment. And I was a little more confident, except for the fact that this went on for years waiting for the one ruling, to the point where I was like, I don't know what's going to happen.
Did it really have to go down in summary judgment, though, or could have the judge gone for trial? I was under the impression that we could have still gone to trial, even though both parties were asking for summary judgment.
We could have.
I feel like everyone agreed. I feel like all the parties agreed that we didn't dispute the facts. What do you think, Matt?
I think it could have easily gone to trial. And in fact, I think that would be the more conservative approach. If I were the judge, I probably would have said, okay, well, we're just going to hear from everyone, because then I get to use my magical credibility powers. And now all the things that I find are facts are tested by clear error, as opposed to an appeal from summary judgment motion, which is de novo, meaning on appeal, all of the factual issues, to the extent there are any, the state gets to say, oh, well, you take all of these things in the light most favorable to me, because that's how summary judgment works. I lost. So on appeal, it's a real question of whether the evidence truly supports all these, such that there is no question of fact. So I was very worried about that possibility.
So could it go from appeal to trial, or is the appeal process going to just, is the appeal process limited to the facts already on record?
It depends on what they argue. For example, in Newsweek, we're arguing for a trial. We lost at summary judgment stage. We filed a motion. You can still lose on a motion for summary judgment and appeal and say, hey, you know what? Fine, maybe I should have lost, but I still should have gotten a trial. They could argue that. Given the state of evidence in this case, I think it's unlikely, because as a matter of fact, the evidence really did show that they said what they said. It was all public commentary. People testified to it in deposition, so it's not really subject of dispute. As to the stuff that we won on, they didn't dispute any of our facts or evidence. They didn't have anyone coming in and saying, oh, well, actually, you don't have any religious beliefs. You don't actually have any ritual activity, etc. So it's unlikely that they're going to say we want a trial. But also, I think that if they don't specifically ask for one, I don't think the Eighth Circuit's going to say, yeah, we need to have a trial on this one.
Nice. Well, I think we need to put Baphomet back into active duty. What do you think?
Oh, yeah.
Any thoughts on where and when?
The current best candidate is Texas. Texas has just put in a very Catholic statue of Mother Mary pregnant with Jesus. They're denying that that's what it is, but it's a very famous statue, and the guy who sculpted it is a very famous Catholic sculptor. So more likely than not, that's where my eyes are most fixed right now.
Erica, do you know of any good venues at which we should have a upcoming Baphomet victory party in or around Little Rock?
I mean, honestly, I think a celebration on the Capitol grounds would be fantastic.
Another Capitol grounds rally.
Yep.
Kind of like the full circle event.
Yes.
Yeah, I don't know. I feel like we escaped with our lives on the last one.
Probably.
Yeah, let's not tempt fate, perhaps, maybe. Yeah.
That's another thing they missed too. We were getting chased on the way out. That's something people don't realize either. Like, some of those armed people were trying to follow where I was, and they knew where I had gotten out of the car. And I think we faked them out, because I was going the other direction to get into a different car to leave. And somebody started running along, and I remember Kim from Atlanta started like heading some guy off physically in a parking lot or something like that. And then we drove off, and somebody was tailing us, and another person was driving behind us who cut that person off and slammed on the brakes to give us the distance to be able to go. But it was like we actually had to make that kind of escape from the Capitol. I'm actually kind of surprised that bullets didn't start flying with the amount of people indicating that that's what was going to happen. So I don't know. I don't know how appealing a Capitol rally is again at this point. Especially, I think people are a little more trigger happy now.
Yeah, don't come to us. We'll come to you. We'll come to you.
Go to Fayetteville. That's a far more liberal area. The kids would probably love it, I'm sure.
And what wasn't the band? It was the band I Hate God, right? Spelled EYEHATEGOD. I think it all is one word. Was playing at a venue in Little Rock, and I think on their flyer they used a picture of Jason Rapert, and he threw a fucking fit.
Oh yeah,
And
he was
I don't
eating a
know.
baby. He was eating a
Yeah,
baby in
yeah.
the picture. I remember that flyer. I love I Hate God. It's a band I actually listen to.
Yeah, I don't know if he generated any protests at the venue or anything like that.
I think
But
he
so I
really
don't know what, even if we had an event at Little Rock, if that would, that's a lot different than having something at the Capitol, but I don't even know now if that would generate a reaction.
I don't know.
Hard to say.
The thing that I wonder about too is it seems that the people shit their pants more when we challenge something, when we prevail or we make any steps towards it. No one seems to really pay attention. It's an interesting phenomenon actually. I think that particular venue was like a pizza place or something. I'm not sure if it's still around. But that's what I remember the flyer was for. But yeah, whenever we raise our head and we're like, hey guys, can we participate? Everyone goes fucking berserk. But then everyone kind of forgets about it. I am curious if this story catches wind publicly a little more than it has already, because this is a pretty historic victory, in my opinion. But yeah, so far, I haven't seen a lot of media on it.
I feel like the theocratic right, they ignore their losses and tell everybody that they have a commanding presence, and this is their nation, this is their way, their beliefs forged the law, and they pretend that these things didn't happen, that these setbacks didn't take place, uh, because I guess they're a little more dedicated to not demoralizing their base, whereas on the other side, we only focus on losses and ignore the wins. And I think that's a real failing of what identifies as the left, the activist left, is they're obsessed with their losses. They really focus on those and cultivate grievance and ignore the wins. And I think that doesn't serve us as well as the behavior on the other side, which is they get up early, they vote, they know where they stand on an issue, and they go at it 100%. And that we don't see that reaction, I think, on the other side to our to our loss. And that's how I feel about that.
Yeah, the left is addicted to losing, and I think it's unfortunate. But yeah, the left is typically more concerned with tearing down imperfect allies than getting together and trying to have any kind of solidarity at this point. I do think that's a big failure of that kind of politicking. Yeah, the right, they're excellent at banding together over causes. I mean, they're incredible at it. They'll put aside fucking anything to band together. I mean, look at the certain files, the Epstein files. They're like, oh, I don't give a shit. That's fine now because it's we're rallying around our guy. I mean, it's like extreme in the other direction. So it is all of this is an interesting phenomenon.
Yeah, where they're political candidates who they have advancing the Christian nationalist cause, and how far and away they seem to be from the morals they claim to advocate for. It's concerning and it's depressing. And how long was it since we had an actual motion in the case to when we got the ruling? It was like 3 years of dead air, wasn't it?
I remember we orally argued it 2.5 years before the decision came out. I don't remember when the last motion was. Probably, I think it was March or April of 2023, because we were orally arguing it in July. So almost exactly 4 years. No, 3 years.
I know I asked you in that time what you thought the delay was, and nobody had any idea what it could be. But now that there's a ruling, does that change anything? Does that give you guys a sense of why it might have taken this long to happen? I feel like it was posted late on a Tuesday during a heavy news cycle, uh, going into April 1st, maybe to try to mitigate the news the best it could. But I also don't know why it would have taken this long to get there, even being such a lengthy ruling as it was, what do you think the judge might have been waiting for?
I don't think the judge was waiting. I think the judge is just very thorough. Most judges that I see will rule on summary judgment motions without going point by point and ascertaining what each discrete material fact, whether or not it is disputed. Usually I kind of get the sense that they shortcut things by looking for some issue of law or some very narrow fact issue that they can hang their hat on. So, I mean, you have three parties each filing, no, four parties each filing motions for summary judgment. That's four sets of material facts that you multiply by two to see, who's fighting about what, if anything. And then looking at the evidence itself, I get the strong sense that the judge actually looked at the evidence, which is not necessarily a true statement in all of my cases. It's a bleeding edge issue of establishment clause law. When we started this lawsuit, there was a thing called Lemon versus Kurtzman, the Lemon test, and it was kind of like, well, no one seems to really follow it, and we're not sure if it's still around, but it hasn't been overruled. Well, all of the attorneys chose not to argue Lemon because of a recent Supreme Court case. Judge applied Lemon. It's because it has not been expressly overruled. So it is 148 pages because it's very thorough. And that level of thoroughness takes a lot of time. And you got to remember also, this judge has like 1,000 cases on her docket, like all judges do. So.
And was there anything that really stood out to any of you in the ruling?
Well, first of all, I would say once I saw the ruling, I was like, oh, this is why it took so long, because it was so thorough. And even when I was giving you that heart attack phone call, it's because I was trying to read simultaneously the ruling and the summary, and I'm like, oh shit, there's a lot of stuff here. But the thing that I really enjoyed, and I will say enjoyed about the ruling, was the definition of Baphomet. That it actually
it went into detail talking about the philosophical basis of the design of the Baphomet monument.
It was
which
fantastic.
Made it all worth it that we did those presentations and things like that.
Yeah, and the fact that she paid attention, the judge paid attention to those presentations of what Baphomet means to us, not to the world, everyone's stupid ass opinions, but like what Baphomet means to us. And I was reading that. I mean, I thought it was beautiful. I was like, this is legendary. Just this alone, where there's a federal ruling of what Baphomet means to us, and it was so clear and articulate, and it was that part almost gave me chills, because I'm like, this is amazing that she paid attention to that and did it real justice in that ruling. That's one of the things that really stood out to me.
Yeah, the ruling was such that it almost acts as a primer for the Satanic Temple, where if somebody wants to learn more about the Satanic Temple, this ruling actually serves as in some ways as a good summary and gives a good deal of background on us and lays it all out very clearly and with a lot of citation and with a lot of direct quotes too. It's very well done. I don't think we could have asked for better in this. There was the issue though where we were talking about at first our position is that the Ten Commandments has to come down or the Baphomet monument has to go up alongside it. But then after so many years, the idea of, the fact that the Ten Commandments had that placement there for so long led us to feel that the way to rectify this would be to give equal time to the Baphomet. The ruling didn't address that, but instead came from the perspective that our concerns were mitigated because the Ten Commandments comes down, kind of avoiding the question of the Baphomet going up. And the question came up, is that something we want to pursue? And the thinking was that we should put Baphomet into active duty elsewhere. But you but Matt and Stu also see a downside to trying to pursue placement of Baphomet and snatching potential defeat from the jaws of victory. Did you want to say anything about that?
Yeah, my complaint and intervention was abundantly clear. Either take theirs down or put ours up. My motion for summary judgment kind of changed things a little bit. It said, no, put ours up regardless. We want to have equal uptime for the same amount of uptime as Ten Commandments had. If Ten Commandments doesn't go down, then that is just permanently affixing it. But even if you do take it down, put ours up, it ended up being 1776 days that the Ten Commandments monument was up at the time of my motion. So that's what we said, 1776 days plus one per day while we wait on a ruling. She did not take me up on the motion for summary judgment. So our, mechanism for relief there would be filing a post-judgment motion, which, as I said, is frowned upon, or cross-appealing, which is going to make the Eighth Circuit's head spin. So I foresee a low probability of success just from the practicality of it. I think there is also a difficulty with convincing the judiciary to force anyone to speak, especially a government to speak, because the judge specifically filed the Ten Commandments monument as government speech. So compelled speech has its own rigmarole they have to go through to justify it. So I think that it simplifies things, and I think that the best thing for us to do is say, we asked for this, we got what we asked for, take the win, be happy with it, and move on to the next place. If you want to run the risk there, we can run the risk there.
And do you think this helps us moving on to the next place? Or is it back to square one with that, and this doesn't really matter in that regard?
I foresee it is almost certain that we should never have to deal with, are we a real religion, as an argument anymore. I was a little bit surprised to see it in Cave, but they kind of started it, and then we got Scottsdale over and done with before they could get to summary judgment in this case. So it could have just been a strategy that they chose to not change. But, we have litigation upcoming in Iowa. I don't expect that that's going to be an issue there. I have been very pleased to see that there has not been litigation over it, to my awareness, in the reproductive religious rights or religious reproductive rights campaign. So
I think you're
those,
giving these guys too much credit. I think they've got one script, and I've seen some of these guys from the general's offices, and they are fucking stupid.
well, they're fucking stupid, but they also think about what arguments have a shot in hell at actually winning. So they know that they can't fight us on equal footing with our "are we a religion" argument. We're going to beat them 10 out of 10 times. They might not like it, and someone like Cantrell might actually argue against it. But from my experience so far, everything since really Scottsdale, it's just been a non-starter for any defendants, even where they're fighting tooth and nail about basically everything. So that's definitely, that aspect of this is definitely going to help us. I think that there are certain fact findings that we will probably make use of later on. Things like identifying what does Baphomet mean, for example. Now I don't have to come up with an affidavit. I should be able to just point to a case in which it's already been found. So there's little fact issues like that. But the next Ten Commandments monument, it may or may not be helpful. I think it's really the Eighth Circuit that's going to be very useful.
Yeah, I think once Eighth Circuit comes down, and I think now I have some confidence that this is going to come down in our favor. But I think once the Eighth Circuit, if they appeal and this becomes precedent, I think that's rock solid. I mean, that's going to set us up to defeat their main defense on those grounds forever. So this is awesome. This is, we've been fighting this for over a decade now, and this is the one that I think could really make a change.
There is another matter that we should probably talk about, which is the Eighth Circuit's going to hear another Ten Commandments like case before ours. The Ten Commandments display acts in Arkansas classrooms. was enjoined preliminarily before we got our MSJ order. So
Yeah, like 2 weeks before.
yeah, I don't know what the timing was, but that was done by Judge Brooks out of the Western District in Fayetteville. Judge Baker here in the Eastern District has ours. So the Eighth Circuit, there's a theoretical possibility that they might consolidate it. We could be arguing it on or around the same time. We should probably be keeping an eye on that case, and we come to think of it, might want to do an amicus brief in that case too.
Yeah.
I think
Well,
probably
we
should.
haven't seen the last of this making its rounds through social media and media. Once the Russian bots get their orders to hammer on this, then I think everybody will be talking about it. But 10 years later, here it is. We're just getting started. It was great seeing you both again, Mason and Erica. And thanks for being on, Matt and Stu, as you usually are. And I hope I see you all in Baltimore.
Looks like that's happening. And
Very
always
good.
a pleasure. Always a pleasure, and it's great to have one of these where we have a solid victory. So yeah, like you said, 10 years in the making, and we're just getting started. Thanks, everybody.
Thank you. Good night.
Good night.